All right, you're going to pass that real estate exam by prep with questions and answers, and of course, your vocabulary on some of my other videos. Oh my gosh, so I just got back from jogging, and so you're going to notice that I'm rather red and don't have my usual lipstick. Oh my gosh, what a bummer, huh? So give me a moment. All right. So, oh gosh, man, today was a crazy day. Okay. And just came back from walking and jogging in this heat. Hi, Fabiola Ramos, the doggy and me. All right. So we're going to continue. So I had a request and see if I would start with Texas state questions first. So that's what we're going to do today. So anybody watching the replay, this class is designed to allow students to participate. I give them a chance to answer. So while you're watching the replay, hey, just fast forward so you can quickly see the answers and go through the questions. Hopefully one of these days you will participate in person. All right, so this is Wild Lily Handy coming to you from YouTube Agent Prep in San Antonio. So this is the book that we're using. We're continuing on. It's listed down in the description, so you may purchase it from Amazon, and also they publish 24 other states throughout the U.S. It includes national questions and reviews for all the different sections that you're tested on the actual exam, and then you will review math, and it has national and your particular state in questions. Okay, so, and I just noticed something from Lisbeth. Lisbeth says, hi, Fabiola. Hi, Cindy Cook. And I missed it by 3. Hey, Lisbeth, I know it doesn't feel good, but that is awesome, okay? Just by 3. So you are really close. And then the state by 4. Well, a lot of individuals say that the state is really hard. So, thank you so much for sharing it with us, because that'll give others also encouragement that, hey, don't be afraid and shy to disclose about how you do on the exams, and that we need to study some more. So thank you for letting us know. Yes, I thought about you today on the 29th. You will get it next time, all right? Not to fear. You are here and you are blessed, and we'll practice some more until you pass. All right, so we're starting today with Texas state questions. Yes, I'm very proud of you, Lisbeth. You've been very persistent and not giving up in the last few years. So Cindy says, I think that the state was a little tougher than national as well. Thank you for sharing that, Cindy. It gives a lot of students hope when all of you make comments and share either on here, on YouTube, on the Facebook group. Okay, there are more members on the Facebook group, and then also on Messenger. So next time, Liz, and she says, thanks. Oh, and hey, by the way, y'all, I got to share, right? I said I was at 998 subscribers. Well, I hit 102 this morning. Woohoo! Oh my gosh, I'm so excited. That's a major milestone on YouTube, okay, that I hit 1,000 subscribers, and I already have all the watching hours. We're required to have 4,000, and I've got almost 8,000 or 6,000. So thank all of you for your support, for your encouraging me, following me, watching me, and sharing it with others. All right. So exciting, so exciting. And I also got that offer accepted that I was showing on Saturday. Remember, I also mentioned that. I'm scared to schedule. I understand, Jaylene. So was I. Don't feel bad. Yay, congratulations. So, yay, you're at 1K. Yes, 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 Jaylene. Eventually you will too. Woohoo! All right. So enough fun and success. Let's get down to business. All right. So these are Texas State. Let me put my phone. I forgot to put it on mute. Actually, I do have it on mute. And that way we won't have any interruptions. Okay. So what is the primary function of an appointed intermediary? A, to stand in for the primary intermediary in the event of an absence or illness. B, to give the principals a choice in which broker they prefer to represent them. C, to represent the principal party that the broker does not represent. Or D, to carry out specific instructions from the intermediary for the benefit of the principal party. Type your answer in the chat. Woo, you girls, you ladies. Okay, so we're all girls, right? There's a website on Facebook of a whole bunch of very successful women and with EXP and others, and they're called Girls with Grit Collective. Yes, the answer is D. Awesome, very good. Keep up the awesome work and participating. All right, 11D. Oh, okay. So here I am telling you all how to do things and then I mess up, right? So 14.11D. And why is it 14? It's a test. Okay. So it's a test. And today, okay, we're continuing, okay, with agency and brokerage relationships down here. Agency and brokerage relationships. That's what these questions on this test are about. On test number 14. So when you buy the book or Kindle, you can follow along with it. All right, 14.11D. All right, number 12. Which of the following accurately describes a broker's duty in managing operations? Okay, so A, the broker must develop then abide by his or her rules for handling trust funds and managing the trust account. B, the broker may delegate compliance duties, but must ensure timely communication between his delegated sales agents and clients. C, the broker may delegate selling and prospecting activities, but may not delegate property management activities. D, all listings in sales agents' names must be maintained to accurately reflect each agent's address and contact date. So which of the following accurately describes a broker's duty in managing operations? Anyone? Okay, the answer here is B. The broker may delegate compliance duties because everybody has to meet the compliance of the contracts and be legal to avoid any error and omissions, but must ensure timely communications between their delegated sales agents and clients. Okay, so the compliance individuals are not the realtors, okay, nor the clients, of course. So there will be an assigned realtor or broker that reviews all contracts and meets all the compliance requirements. And they've got to let the realtors know that, yep, all is okay. It looks good, no mistakes, or you need to correct or change this and have the client's initial. All right, so the answer was 1412B. Awesome. So anybody that just joined, today we are doing Texas state questions, and then we will do the national that applies to all 50 states. Number 13. A broker must discharge numerous duties related to her agency relationships. Which of the following is such a duty? So they must discharge numerous duties. So which one of the following is such a duty? A, the broker owes customers honest disclosure of the client's financial status and property value. B, the broker owes the fiduciary obligations of fairness and impartiality in all dealings with clients. C, the broker is obligated to justify any and all subordinate terminations with the TREC. Or D, the broker must disclose to the principal all known information affecting the client's decision making unless legally prohibited. All right, already have 14D on here. Let's see, anybody else? And yes, Jaylene, that is correct. It is 14D. Very good, Cindy. So the broker must disclose to the principal all known information affecting the client's decision making unless legally prohibited. Okay, because those clients are going to be making a lot of major decisions, right? And anything on the contracts, on the property, okay, impact the decision process of the client. Okay, number 14. Transaction, listing, and closing files must be maintained from the date of closing or expiration for a total of what? A, 1 year, B, 2 years, C, 3 years, or D, 4 years. While you put your answer in the chatty chat, I'm going to get my water. I thought I had it next to me. So type your answer in the chatty chat. What do I do with my water? Okay, found my water. All right, so what do we have so far? We've got D. Yes, and that is correct. 14D, 4 years, right? Awesome. Okay, number 15. Wow, that's going to be small. Okay, I'm going to have to read it from another screen. Brokers are required to maintain office policies and procedures to ensure that, among other things, sponsored sales agents keep current on law changes and their continuing education requirements. Which of the following is not a good served by policy and procedure manuals? A goal, I'm sorry, not a good. Which of the following is not a goal served by policy and procedures? A, advertising compliance. B, proper records maintenance. C, optimized web presence for making listings. Or D, ensuring practicing licensees have active licenses. So which one is not a goal served by policies and procedures? You would ask here, are web presence required? There are some individuals that do old school. Yes, that is correct. Very good. C, optimized web presence for marketing listings. Okay, that is not required. That is not a goal. That is an individual preference. Of course, it's best to have it on there to be on social media. However, it is not required. Hi, Vicki. Thanks for joining us. We are doing Texas state questions first today and then going into national. All right, number 16. In the course of brokerage practice, licensees share or split fees. Which of the following compensation scenarios would constitute a license law violation? A, sharing or rebating a commission with another sales agent with prior broker and principal approval. B, paying a one-time referral fee to an unlicensed party who is not practicing real estate. C, splitting a commission with an unlicensed party who is performing licensed activities. Or D, sharing or splitting a commission with a sponsoring broker. So in the course of brokerage practice, licenses share or split fees. Which of the following compensation scenarios would constitute license law violation? Yes, number C, that is correct. Splitting a commission with an unlicensed party who is performing licensed activities. So what does it say here? It says licensees can share compensation via a rebate provided there is prior written consent from the broker and the rebating licensee's client. Licensees may also pay referrals provided they do not perform license activities or lead the public to believe that the recipient is licensed. But you cannot compensate a party who is practicing without a license. So 1416C. Everybody got that correct. Awesome. Okay, number 17. As a rule, rebates, commissions, and service provider fees in real estate transactions must be transparent. In that context, which of the following scenarios is in compliance with license law? A, without the buyer's consent, a service provider rendering services to the buyer pays the seller's representative a commission for the referral. B, a licensee discloses and obtains consent from her seller client to receive a fee from a property inspector. C, a licensee accepts a service provider fee that is contingent on the client purchasing the provider's services. Or D, sorry about that, a licensee who represents the buyer enters a contract with a service provider to perform services for the buyer on behalf of the provider. So which of the following scenarios is in compliance with license law? In other words, it's acceptable to be done. Little tricky? No, it is not D. The answer is actually B. A licensee discloses and obtains consent from her seller to receive a fee from a property inspector. So in our contracts, if we have a relationship with a contractor, a home warranty company, or others, we provide a form, a disclosure for our clients to sign it, to know that if they happen to use that provider, we may receive a fee, okay? A service provider fee. So that's starting to happen more and more when there are a lot of affiliations that we recommend products. And so businesses are getting business, but we get nothing. And we're in the business of getting commission, right? We earn commission. A lot of times they don't refer anything back to us because they work with so many realtors. So then this is a way that we have to disclose to our clients before we can actually get a service provider fee. So D says, a licensee who represents the buyer enters a contract with a service provider to perform services for the buyer on behalf of the provider. Okay, well, the buyer has to agree, all right, in order to accept that service, okay, from the provider. We can't have any non-disclosed kickbacks, okay, non-disclosed fees or affiliations without disclosing. All right, number 18. Which of the following is true regarding referrals? A, the party receiving the referral must be licensed. B, referring parties need not be licensed under any condition. C, the referring party must be licensed regardless of compensation expectation. Or D, the referring party must be licensed if expecting compensation for the referral. So I had a student ask me about this, that, oh, they were going to, can a referral fee be paid to another realtor? Yes, that's a lot of how we do business. When someone is moving into San Antonio, into your city, or they're moving away from your city, we help find a realtor in the other area, and we refer our client to them on the basis that we will get paid a 25%, 20%, 30%, whatever is negotiated between the two realtors for that client. And then we connect the client, the principal, and the other realtor. And we have to sign a form, what is called a referral form. So what would the answer be here? 1418. Be very careful when reading the answers, okay? Because some seem like they are true, and they could be true, but there's a little bit missing. So the actual answer here is D. The referring party must be licensed if expecting compensation for the referral. Okay, so let's see what the book says. The book says the referring prospective buyer, seller, landlord, or tenant, referring them to another person in connection with a proposed real estate transaction, is an act requiring the person making the referral to be licensed if the referral is made with the expectation of receiving valuable consideration in the Texas Code S535.2. So anytime we're going to get compensation, so that compensation, that percentage of commission, will go through our broker from the other broker, and then we get our percentage. So that's another way to make commission from transactions. We don't always do it by helping our clients sell a transaction or buy. We refer to other areas. So you want to have a good relationship with realtors, network with realtors in other cities and other states. And there are a lot of referral websites out there. Let's see, someone answered A and C. So it says A, the party receiving the referral must be licensed. Well, how about the party referring it? So only a good referral. Hi, Anna. Good afternoon. Thank you for the good vibes. Says, hi, good vibes. So the party receiving the referral must be licensed, but the party sending the referral also must be licensed because they're going to be receiving compensation. So that's why I said, okay, well, yeah, it sounds right. However, it's missing one key word. Both parties have to be licensed. And then C, the referring party must be licensed regardless of compensation expectations. Well, both the referring and the referred party have to be licensed. Okay, and let's see, must be licensed regardless of compensation expectation. Okay, so it'll depend, okay, on that compensation. However, anybody that is getting or giving a referral, okay, is going to gain compensation. Sometimes they won't, like let's say it's a rental referral, and rentals in Texas don't sometimes make much money, so we don't ask for a compensation. So it doesn't have to be compensated, okay? And then, so D was the referring party must be licensed if expecting compensation for the referral. So both parties must be licensed in essence, okay? So the answer there was D, or is D. All right, number 19. Which of the following would be categorized as an unlicensed activity not requiring a license? A, developing a mailing campaign for a new licensee. B, responding to phone inquiries regarding the condition of an open house listing. C, confirming a listing address on the phone. D, assimilating recently sold properties into a price strategy for a builder. So a lot of times we realtors will have assistants, okay? And they can do a lot of things, but that doesn't require a license. There are a lot of things that they cannot interact with clients and provide advice and give specifics about properties. So yes, the correct answer is C, 1419C, confirming a listing address on the phone. Because right there, you're just confirming an address. Developing a mailing campaign, well, only the realtor is going to know about what they want to market for their business, okay, the mailing campaign. So they need to develop that, not the assistant. Responding to phone inquiries requiring the condition of an open house listing, no, can't discuss conditions. That requires a license. Assimilating recently sold properties into a price strategy, no, that requires a license, okay? So the only accurate answer is C. All right, number 20. Which of the following would not, okay, not be classified as an unlicensed activity? Which of the following would positively be defined as a licensed activity? So A, supervising a new licensee. B, inputting data on a new listing into MLS. C, scheduling and confirming showing appointments. Or D, providing mortgage interest rates of area banks to a consumer. So which of the following would positively be defined as a licensed activity? Type your answer in the chatty chat. No, assistants can input data into the MLS for the realtor. Okay. And so that is not correct. The correct answer is supervising a new licensee. Okay. That requires positively a licensed activity. So it says which one would not be classified as an unlicensed activity. In other words, the person has to be licensed to do it. Supervising a new licensee requires a license. Scheduling and confirming showing appointments, no. Okay, there are a lot of people that hire services for calling just to schedule and confirm appointments. They're not discussing anything about the property. Providing mortgage interest rates of area banks to a consumer, yeah, that requires our real estate license. That's part of what we're discussing. We can, if not, refer them to the internet, okay, to Google it, or to talk to a lender. Yeah, some people don't believe in going with your gut, but I do. And there is a lot to be said by going with your gut. A lot of people make major decisions going with their gut instinct. Okay. Personal instinct. Number 21. Which of the following statements is true regarding the seller's disclosure note of property condition? So the seller's disclosure notice document. A, it is to be completed and given to the buyer at the seller's option and discretion. B, it must be completed on or before the effective date of a binding purchase agreement. C, licensees and firms may design their own form as there is no promulgated or suggested form provided by TREC. Or D, if a seller is not aware of a particular property condition item, he or she must have such item inspected for workability. So which of those statements is true? Okay, anybody? Type it on the chat. Must be challenging. No, it is not A. In a contract, nothing is done by seller's option or discretion. At least not with a seller's disclosure notice. They are required for the seller to disclose. So the answer is B. It must be completed on or before the effective date of a binding purchase agreement. And what is the effective date? That's after everybody has signed, initialed, and delivered and notified, right? Notified and delivered. So it is to be completed and given to a buyer at the seller's option and discretion. No. We as realtors will use and provide those disclosures. You'll know that, there are certain individuals that are exempt from doing a seller's disclosure notice, okay, like attorneys or in foreclosures with the banks or with an executor or an administrator assigned by the court. Those do not require the seller's disclosures, right? Because they're not aware about the condition of the property. Individuals that inherited a home, okay, yes, because they inherited it, now they own it, then it's theirs and they must disclose. Okay. It's a 5-page document in the state of Texas. Number 22. Did y'all get that? Okay, you're going to hear a little noise in the background because I forgot to get my YouTube in case somebody posts a question on there. All right, so number 22. Some exception exists to the rules for completing the seller's property condition report. Which of the following is not such an exception? Okay, I just stated some things. A father transfers the property to his daughter. B, the property is used for residential purposes. C, the property is new and has not been owned before. C, the transaction is a foreclosure sale. So some exceptions exist for the rules for completing the seller's property condition report. Which of the following is not such an exception? Good. I'm glad you understood. Yes, ma'am. Yes, mom. I get it. Yes, mom. Except it would be an H, right? M-A-H-N. Okay, type your answer in the chat. Which one is it? So which of the following is not such an exception? Which one definitely requires the seller's property condition report to be filled? Oh, no, no, no. If it's a brand new construction, a seller's disclosure notice is not required. What will be required? A certification of occupancy that all inspections have been done. Therefore, the answer is B. The property is used for residential purposes. That is not an exception, okay? You know, some of the other, I mean, yes, the property is going to be used for residential, but it could be used right as an investment, but they still know and have to complete it. So let me, okay, so let's read what the book says. So sellers must disclose the property condition if the use is residential. Other exceptions include estate sales, lender-to-lender sales, conveyances to other co-owners, bankruptcies, and conveyances where the improvement value is less than 5% of the property value. Okay, so that one, the property being used for residential purposes is not an exception. Okay. So estate sales, okay, because somebody died, now they're selling everything in the property from lender to lender, okay, foreclosures, sales conveyances to other co-owners. It's not are exceptions, right? But they will have to end up filling one when it gets sold. All right, so that was, hi, Miss Stacy. Thank you for joining us. Oh, I didn't type it on here, or did I? Yes, I did. So 1422B. All right, number 1423. So anybody who just came in, we are doing Texas State questions today first. Hi, Dawn. Sorry, I didn't say hello. And so we're doing Texas State. Instead, normally we do national, and then we do state. So today I'm doing a state and then doing national. All right, number 23. A seller delivers the seller's property condition disclosure to the buyer after the deadline. What is the consequence? A, the licensee has violated license law. B, the seller's contract is nullified. C, the buyer may rescind the contract within 7 days following receipt of the disclosure, or the buyer can compel the seller to repair any undisclosed defects. So let's see, number 23. So far, I have C. Si, oui, oui, monsieur. And yes, that is correct. So number C, letter C, the buyer may rescind the contract within 7 days following receipt of the disclosure. You know, especially if the closing date. However, they always have a time period to rescind a contract if they're not satisfied with the disclosure. So it specifies that in the contract. Let me see if the answer says anything different. So failure to make the condition disclosure to the seller prior to the binding date creates a 7-day rescission window for the buyer. The contract remains in effect unless manifestly terminated by the buyer. However, the licensee, while wise to advise the seller about the report, is not liable for the seller's meeting the deadline. Okay, no matter, we might be able to tell our seller, ask them so many times, okay, I had one such condition and it was never completed. So sometimes we have to meet with them to help them. Now, we can't do the seller's disclosures for them. We can't answer the questions for them. However, if they ask us questions, we can help them understand, okay, or they can take it to an attorney. But that's going to cost money, right? Because they have to individually complete it themselves. We cannot complete and help them complete that or answer questions on there for them and say, oh, you should put this answer. Oh, yeah, you should put that answer. We can't do that. All right, number 24. So it's not the realtor's fault if it did not get completed. Unless the client says, hey, the realtor never shared it with me, so I didn't know. Then yes, we have a problem. Realtor has a problem. All right, number 24. Oh, this is a long one. Takes long for me to read them when I'm in an exam. So I used to click them for review. All right, because you basically have about 1 minute per answer, per question. Okay, number 24, a homeowner resides in a new subdivision managed by a homeowners association. What obligation, if any, does this fact create whenever the owner decides to sell? Okay, so they live in a homeowners association. What obligation, if any, does this fact create whenever the owner decides to sell? So A, the owner must advise the buyer of the managing entity and associated fees prior to closing. Excuse me. The owner must advise the buyer of all homeowner obligations or face a 30-day exposure contract rescission. C, the licensee must disclose the association's existence or face disciplinary action. Or D, the owner must disclose the existence of the association and all obligations accompanying membership. So let's see. So Miss Stacy, you must have a major delay. And for number 22, you answered C, and the actual answer was B. Okay, Jaylene says D. Dawn says C. Anybody else? The actual answer is D. The owner must disclose the existence of the association and all obligations accompanying membership. Okay, so let me, for those that missed it. All right, so we had C, we. So the licensee must disclose the association existence or face disciplinary action. No, that's a requirement for the seller to disclose because they're the ones that they live in the association. Now, we as a realtor will want to research that and find out, okay, when we look up the county records and any other information, it'll let us know that it's in an association. So we will then, ask the seller to provide that information and to order it. And as long as it's ordered either prior or during the contract, okay, however, the seller must disclose that. And so let's see, A said, the owner must advise any buyer of the managing entity and associated fee prior to closing. Okay, that's different than the owner must disclose. Okay, so the owner, they have to disclose, not necessarily advise the existence. Okay, so D says the owner must disclose the existence of the association and all obligations versus the owner must advise any buyer of the managing entity and associated fees prior to closing. Well, there's more to it than that, right? What are the obligations? What do they have to pay for? What can they and cannot do? Okay, so we sometimes get the homeowner association documents from the seller, or we contact the homeowner association. If not, then there's a one page that we complete for the owner to complete, and then the title company will order all the documents from the homeowners association if the seller does not have them. Because a lot of times they want to have it from a third party to make sure that they are current and accurate. So, okay, I already typed the answer. All right, number 25. In addition to obligations regarding property condition and homeowners associations, If a selling homeowner resides on a property abutting tidal water, he or she must do what? A, disclose the mean, high, and low tide levels in a letter signed by all principals. D, disclose the changeability of the property's boundaries owing to erosion. C, disclose the boundary line out into the water since the waterway is navigable. Or D, provide a history of all landfills occurring over the prior 10 years. So the property is abutting tidal water. So what must the seller do? So obviously 3 of them say disclose. So yes, it's one of them, A, B, or D. I mean, A, B, or C, pardon me. So Jaylene says B. Anybody else? And yes, the answer is B. Disclose the changeability of the property's boundaries owing to erosion. Oh, boy, I typed 24 instead of 25. Luckily, I did it on Facebook, and on Facebook, I learned from one of my students that once you write a comment, you can edit. I had to learn it from a student, correct? This long ago, okay, because I wasn't that savvy on Facebook. All right, very good. 1425B. Okay, very good. All right, y'all did well. Okay, let me look on YouTube, Facebook, and see if anybody's had any questions, because I have not looked on YouTube. So anyway, Miss Stacy said good evening to everyone. Okay, somewhere earlier. Oh, here we go. It says good evening, everyone. She posted that on YouTube, which I prefer for all of you to watch the webinar or the class on YouTube versus Facebook, right? Because it helps my analytics and watch time. Okay, so that was the end of that particular chapter. Okay, and that chapter was, or that test was test 14, agency and brokerage relationships. Okay, so now we're going to go into test number 15, which has to do with contracts. Okay, so we've done 15 questions and it's 6:48. Okay, we can go a little bit longer. All right, any questions on agency and brokerage? That was your area of weakness, Cindy, right? So now we've covered the whole area. If you're still concerned about it, go back and review this video, and I think, all the way to the beginning, because that was, no, I don't think it's up to the first. We started out with test 11. So you can do all of test 14, okay, to review about agency and brokerage. Okay, so contract. So no questions. Nope, nope, nope. Okay, very good. So this is the time where you can ask. All right, contracts. So this is your residential 1 to 4 resale contract. And it can be a commercial contract, land contract, unimproved land contract, new construction contract, condominium contract. So a lot of different types of contracts, okay? But the one that you mostly study and get tested on, okay, yes, it was agency and brokerage, is the 1 to 4, okay, a family residential resale contract. Okay, that's the one that you predominantly learn on promulgated contracts and that you will get questions on. All right, sometimes you'll find out that for for a new construction, okay, like do you need seller's disclosures? Well, that's not a contract, okay, that's under the agency and brokerage principles of agency, okay, but with not a brand new contract, brand new homes, they've never been lived in, then that requires a new construction contract. Okay. 15.1. Which of the following is true regarding Texas promulgated contracts? A, they are recommended by the Texas Bar at the discretion of member attorneys. B, they must be completed with the assistance of approval of a licensed attorney. C, they replace contracts periodically prepared by principals attorneys. Or D, they must be used for sale and lease transaction with some exceptions. So there are two answers that have the word must. A lot of times those are either correct answers or wrong answers, because not everything is a must. But in here, it's one of those, B or D. Yes, very good. It is D. They must be used for sale and lease transactions with some exceptions. Okay. So if it's a transaction for less than a year, it's not required to be on a contract, and an attorney could write the contracts up if the buyer or the seller wants their attorney to do so. Okay. There are some investors that buy and sell a lot of properties and they just have their attorney take care of everything. Okay. So that's why it says with some exceptions. There are probably other exceptions too, but those are a couple that I could think of. All right, number 2. Licensees may not engage in the unauthorized practice of law. Which of the following would constitute such a violation? So licensees may not engage in unauthorized practice of law. Okay. So which one would constitute a violation? A, insisting that due to legal nature of property transaction, the buyer should obtain competent legal counsel. B, explaining the purpose of a building permit. C, expressing an opinion regarding the validity of a seller's title. Or D, giving a buyer prospect a copy of a subdivision's covenants and restrictions. So which would constitute a violation? Type your answer in the chatty chat. Okay, I see some answers coming up. All right. Yes, Cindy, it is C. Oh, no, Jaylene. The answer is actually C. It's expressing an opinion. Okay, we don't express opinions regarding the validity of a seller's title. That is for an attorney to do. We do not express our opinion on a seller's title. Right? That's the ownership of the property. What's on title? Because the title companies do research, right, on the chain of title, and they provide a summary. So that has to be done by the attorney. I saw express and didn't pick it. Ah, yes. Okay. So 15.2C, expressing an opinion, okay, regarding the validity of a seller's title. So let's see who answered B. Explaining the purpose of a building permit. Yeah, we can explain that. Okay, before they can build a home, they've got to go to the planning department, okay, and get it. And we can look it up on Google and read it for them. Best thing is to refer them to the planning department. That the purpose of a building permit, right, is to be able to build a home and follow the zoning and police laws of the city, county, state. All right, number 3. The practice of completing sales contracts is a tightly regulated activity since so much is at stake for consumers, and that is so true. In that context, which of the following is not an acceptable practice? A, filling in the blanks to a contract form in the middle of negotiations. B, adding a statement of fact desired by both principals. C, adding another blank in a contract clause. Or D, informing a buyer-client that an encumbrance or seller's title may be a big problem for the lender. So which one is not an acceptable practice? Okay, the answer here is, yes, that is correct, Jaylene. It is C, adding another blank in a contract clause, okay? That is modifying a legal contract, promulgated contract, and we cannot do that. That is practicing law. If a buyer wants or seller want to do that, then we advise them to go to an attorney. Number 4. Which of the following is a violation of license law as they relate to contracts? A, using a committee form under certain circumstances. B, entering language onto a contract clause blank that defines what a tenant can or cannot do if the landlord does not make a timely security improvement. C, refusing to load language from promulgated contract A into promulgated contract B for the sake of efficiency. Or D, advising a buyer that a contract is legally binding. So which of the following is a violation of law? Type your answer in the chat. They're challenging, huh? And these are the state questions. They can be challenging in all states. A lot of legality. The answer is B. Entering language into a contract clause blank that defines what a tenant can or cannot do if the landlord does not make a timely security improvement. Okay, we entering language into a contract clause blank, okay, that defines what a tenant can or cannot do. That ends up being in the lease. So here is licensees may not define the rights of a principal in a contract, such as what a tenant can do given a landlord default. Committee forms may be used with commission permission. So we use documents that we have, right? Promulgated documents. Advising clients that contracts are legally binding is a required duty, not an option. Yeah, so Jaylene says the same. So y'all were going to answer, let's see, C. So the answer, so let's see. Refusing to load language from promulgated contract A into promulgated contract B for the sake of efficiency. That's not a violation of law, okay? It's, I'm sorry, because you're refusing to do it, okay? So which of the following is a violation of law? So refusing to load language from contract A into promulgated contract B for the sake of efficiency. Okay, so we don't do it. So let's see what Cindy says. I read it too fast and I didn't see refusing the, yes. right? So, yeah, we definitely refuse that. Okay, so that was 14B. All right, last question for state this evening. For Texas state, during the course of a transaction, the licensee must advise clients of various circumstances where legal counsel should be consulted. In which of the following scenarios should the licensee recommend that the buyer obtain legal counsel? The licensee is selling her own property and has just hired an attorney to represent her. B, a transaction involving several promulgated contracts. C, a contract for deed transaction involving several non-standard contingencies. Or D, a buyer is about to place an offer on a property where the previous resident had AIDS. So during the licensee must advise clients of various circumstances where legal counsel should be consulted. Which of the following should the licensee recommend that the buyer obtain legal counsel? Ooh, I didn't type the answer. Talking to myself. All right, no answers yet. Okay. Challenging, huh? Hi, I'm Winston. The answer is C. That is correct, Cindy. Yes, it is challenging. So a contract for deed transaction involving several non-standard contingencies. So during the course of the licensee must advise clients of various circumstances where legal counsel should be consulted. In which of the following scenarios should the licensee recommend the buyer go to an attorney, legal counsel? When there's a contract for deed transaction, okay, involving several non-standard contingencies. Okay, so the first one says A, the licensee is selling her own property and has just hired an attorney. That's fine. B, a transaction involving several promulgated contracts. That's fine. D, a buyer is about to place an offer on a property where the previous resident had AIDS. That's okay. They don't need an attorney, recommend an attorney, but a contract for deed, yes. So, Winston, I missed the national portion by 4 points. Oh, okay. Yes. Lisbeth just mentioned that too on her exam. So you and Lisbeth are in the same situation of missing 4 on the national exam. Actually, and that's really good. Okay. And I don't know if it's your first, second, or third attempt. However, whichever attempt it is, okay, you're getting very close, right? Because on the national, you have 85 questions and you missed it by 4. So you have to get a 70 out of 80. So 80 times 70 is 56 correct, right? And why do they give us 85 questions? Because brokers also take these exams and they answer more questions and are graded. I'm sorry. Not that they answer more questions. They are graded on more questions. So Lisbeth Winston says, how many attempts have you done it? So first time, I figured 2 to 3 more weeks of studying and I'll be okay. That is great. That's the attitude to take. Okay. Very, very good. That's right. Study some more. Excuse me, do not wait too long. The longer we wait, the more we forget. Okay, so that is a very good to do. All right, 2 to 3 more weeks of studying. Awesome. Review the exam results, and on the book, on the comments down below, Texas Real Estate Sales Exam fourth edition. It's the old book from 2006. That book is awesome because after the exam and the answers, it breaks down all the questions into the different categories that you are tested on the exam. Therefore, on your exam results, it'll tell you which section you need to focus on, right? So so if it's agency and brokerage, then go to that page and look at which questions apply, okay, to brokerage and agency, for example, agency and brokerage, and then study those, focus more on those questions. However, review all questions and work on them until you get 100. Okay. So, so this book also has matching questions. All right. So that was it for Texas state questions. We are shifting to national. So again, this is the book that we're using, and you are free. It's available on the link below, on the description below, so that you can purchase it if you'd like, for 25 different states. And also it includes, of course, Texas. So on the national, we are, okay, still on test number 2, starting with number 6. Okay, so any questions? So let's see, comment. Right, I took note. My worst section was contracts and agency. Oh, okay. So this particular book, okay, on the state portion, you have, let's see, rights, interest. Oh, no, that's the national. Hold on the state. So test number 15 has to do with contracts. And I already did a section on contracts in earlier video. However, go through that old book or this book, okay, or whatever prep book you're doing, and review the summary about contracts and review the contract in detail. I did create a video, particularly just on the Texas state contract. I go in detail and review the current contract that was became active April of 2021. Okay, so go watch that video, okay, contracts, so that you can get to know it better. All right. So national questions come next, and that is on what time are we? 7:08. So we're doing national. Give me a moment. I need to shift gears here. All right. So number 2.6. There we go. A court might grant an easement by prescription. Okay. Oh, so you know what? Well, I'll read the question. A town needs to dig a trench across an owner's property to install a sewer line to a neighboring property, and the owner refuses permission. B, a property owner sells the front half of the lot and wants to continue using the driveway to access the rear of the lot. C, a trespasser has been using an owner's property for a certain period of time with the owner's knowledge, but without permission. D, a property owner wants to prevent the owner of an adjoining property from building an improvement that blocks her view. So a court might grant an easement by prescription. So remember, what is by prescription? I discussed that on, what's today, Monday, on Saturday. Okay, so far we have 2C. Oh, I forgot that. So the answer is actually C, okay? Because prescription has to do with like adverse possession, all right? So C, a trespasser has been using an owner's property for a certain period of time with the owner's knowledge, but without permission. So that is by prescription. So Winston, you selected B. A property owner sells the front half of a lot and wants to continue using the driveway. No, so that's an allowed easement that is probably recorded. Or they can go ahead and make an agreement between both and use it. So it says a property sells the front half of a lot and wants to continue using the driveway to access the rear of the lot. You know, they own the rear lot and they probably own the road. So, however, that has to be agreed by both parties and an easement created and recorded, okay, in order for that owner to use it. But that was not by prescription, okay? By prescription is for a squatter adverse possession, and the owner knew about it, but they didn't have permission. Got it? Y'all understand that? Okay, I don't see any questions, so continuing on. So the purpose, number 7, the purpose of a deed restriction is to enable an owner to specify what? Okay, so this is a deed restriction. Remember, there's different levels of restrictions. You have the zoning, and then you can have others. So the purpose of a deed restriction is to enable a new owner to specify what? A, the form of ownership in which a property may be held. B, how long a property must be owned before it can be legally transferred. C, what groups of people are legally excluded from future ownership of a property. Or D, how a property may be used and what improvements may be built on it or not. Yes, the answer is D. How a property may be used and what improvements may be built on it and not. So a developer, a builder will buy a property, right, and subdivide it. And they've already met after, getting their building permits or their plat map approved, right, and their subdivision approved, that they only want certain types of homes on there. And therefore, they can put those on the deed as additional restrictions. So very good. Number 8. Nobody risk that one. Well, I shouldn't say risk. Everything is a risk in life. Everything. From the day we're born, we have risks. All right, number 8. So might as well take a risk. Melinda purchases a house and finances it. The lender in turn places the lien on Melinda's title. The lien in this mortgage transaction is what? So Melinda purchases the house and finances it. The lender in turn places a lien on Melinda's title. That's correct, right? It's a deed with vendor's lien. The lien in this mortgage transaction is what? A, evidence of debt incurred by a property owner. B, a promissory note granted by a property owner as a security for a debt. Or C, the creditor's claim against a property as collateral security for the loan. Or D, the document required to clear clear clouded title. Oh, no, sorry, it is not B. Take another attempt. It is not a promissory note when there is a lien. The answer is C. The creditor's claim against the property as collateral security for the loan. So the lender in turn places a lien on the title, on the deed. Okay, so there's a lien on the deed. And so that is their claims as using the property as collateral security for the loan that they provided to the borrower. Okay. So remember, so in this case, the mortgagee is the lender, and they're receiving the collateral, the security for the loan, and the borrower is the mortgagor because they're the giver of the collateral security on the loan. All right, very good. So do y'all get that? Okay, it's not evidence of debt incurred by a property owner. So they purchase a house and finances it with a lender. So a lender has to put a lien back on their property on the deed, okay? And it's stated also on the, that's where it's stated on title. And so it'll be attached to the property at all times until that lien is paid off. So it is not evidence of a debt. Not a promissory note. A promissory note is where the borrower says, I promise to pay you this according to the interest rate and the terms, 30 years that you requested of me. So it's like giving somebody, you ask somebody for money in the old days and you gave them a piece of paper and you both signed it and you say it's a promise to pay. Okay. The last one, document required to clear title. No. So the document required would be a lien release. Okay. A release of liens that then is recorded and that clears the cloud on the title that there is a lien attached to the property, which creates an encumbrance. Okay. All right. Number 9. So in a lien theory state, what kind of interest does a mortgage lender have in the liened property? A possessory interest. B, a tenancy by mortgage interest. C, a legal interest in a pro rata share of the property. Or D, an equitable interest. Type your answer in the chatty chat. Come on. Yes, they're challenging, but you got to practice. So this is an equitable interest. So it's not A, they don't possess it. Okay, the borrower possesses it. So in a lien theory state, okay, the kind of interest that a mortgage lender has is an equitable interest. It's not a tenancy by mortgage interest. No, that doesn't exist. It's it's like a tenancy in common or something. No. Legal interest in pro rata share of the property. No, that's if more than one person owns it or two person. It's an equitable interest. Okay, they have equity on that property. Okay, they own it if the borrower defaults. They have to go through a foreclosure, of course, a foreclosure proceeding, or the borrower can return it back to the lender, which is called a deed in lieu of foreclosure. So they're returning the deed in lieu of being foreclosed on and ruining their credit to a major situation. All right, so the answer 2.9. All right, number 10. How is a lien terminated? Oh, I mentioned that. A payment in debt, a payment of the debt that is the subject of the lien and recording of the satisfaction. B, transfer of the property that has the lien. C, recording of another lien that is superior. Or D, death of the lienor or lienee. How is a lien terminated? No answers. The answer here is A payment of the debt that is subject to the lien and recording of the satisfaction. So the recording of the satisfaction will mean the lender will provide a release of liens and get that recorded. So the lender will send the release of liens to the borrower, okay, that now is the full owner, and the borrower has to go and record it. $210. Okay. All right. So nobody answered that one. Okay. Number 11. A judge rules in favor of the creditor in a court proceeding and places a judgment lien against all the debtor's assets, including his real property, his or her. This is an example of what? Is it A, voluntary junior lien, B, involuntary superior lien, C, involuntary specific lien, or D, involuntary general lien? So remember, it says in favor of the creditor and puts a judgment lien against all of the debtor's assets, including their real property. So including their real estate. So all assets, including real estate. So what type of a lien is that? Come on, y'all, answer the questions, participate. I mean, there's not hundreds of you on here, but there's a handful. Number 11 is, oh no, it is not C. Okay, it says all the debtor's assets, including their real property. That is considered an involuntary general lien. When it's general, it's broad. They go after everything. They being, IRS or another bank or whatever. They go through the person's, all of their assets in order to get paid. Okay, that's a judgment lien of all the debtor's assets. When it's all of them, it is a general lien. It is very broad. If it is specific, it's going to be on one specific piece of property. Okay. And a junior lien, voluntary, no, this is involuntary. So rules in favor of the creditor. So it went to court. So the borrower didn't volunteer, okay, to get a lien. So it's not voluntary. So it would either be B, C, or D. So we don't have a superior lien here. It's either specific or general. And since they're going after all the assets, then it's general. Like the general in the military, or a general topic, right, is broad. It includes a lot of things. Number 12. A real estate tax lien, a federal income tax lien, a judgment lien, and a mortgage lien are recorded against a property. Which lien will be paid first when the property is sold? A, real estate tax lien, B, federal income tax lien, C, judgment lien, or D, mortgage lien. So this is a priority, a priority list. Okay, so which one has the highest priority? That our properties can be foreclosed, even if everything else is paid for. Okay, no answer yet. The answer here is A. a real estate tax lien. So property taxes have to get paid first. Then the first loan gets paid if there is one. If there isn't a first loan, then maybe a junior, well, there wouldn't be a junior loan. Any other liens that would be attached to it or judgment. So very good, Lisbeth. All right, number 13. A lien holder can change the lien priority of a junior lien by agreeing to do what? A, change the date of the recording. B, lower the amount of the claim. C, cancel the lien. Or D, subordinate the lien. So what can a lien holder do or can change the lien priority of a junior lien by agreeing to do what? A junior lien is after the main lien, right? They can have a first lien and then a second lien, a third lien, second mortgage, third mortgage. So what does that become known as? You're not sure, and that's okay. Great, Lisbeth. It is to subordinate the lien. So the lender is allowing to subordinate the primary lien, okay, the initial main lien that has the main debt. And they only allow that if the borrower's debt to income ratio is there and the equity on the property is sufficient in order to know that the lender knows that if for some reason they default, of course, they have enough equity to sell the first loan. The junior lien won't get any money if the amount of sale covers only the first loan. But the first lender has to approve for there to be a secondary loan, a junior lien. Okay. All right. So they don't cancel the lien when they're doing a lien priority of a junior lien. A junior lien is something that's less than the main lien. So every state has a different foreclosure law. However, they basically have the same priority of liens. Property taxes, first mortgage, junior liens. Number 14, which of the following accurately describes the act of foreclosure? A, a court-ordered acceleration of loan payments. B, the final step in the bankruptcy filing. C, a proceeding to enforce a lien by forcing the sale of a transfer of a secured property. Or D, a proceeding to take equitable title to a property that was liened as security for a mortgage loan. So which one accurately describes the act of foreclosure? No, it is not D. Okay, the answer here is C. So a foreclosure, the act of foreclosure. So yes, C or D said it's a proceeding. However, it's a proceeding to enforce a lien, okay, by forcing the sale of a transfer of a secured property. So they have a lien on the property, okay, and it could be a mortgage or a deed of trust. And it describes, what if it's a deed of trust, then the trustee has title to the property, and they're the ones that will take the steps of starting the foreclosure. If it's a mortgage, they've got to go to court to get an approval to a judgment in order to do the foreclosure. So, but a proceeding to take equity title to a property that was liened as security for a mortgage loan, they already have equitable title. Okay, when there's a lien, the lender already has equitable title. Okay. That's what we did on the other question. What is a security to a property? It is the lender has equitable title. Equitable title. Okay, so say the answer here was C, right? Make sure I type the right answer. All right, number 15. So a property is secured by a mortgage that does not contain a power of sale clause or due on sale clause. To foreclose, the lien holder will have to do what? A, file a deficiency suit. B, file a foreclosure suit. C, file a suit in quiet title. Or D, obtain a quitclaim deed. So a property is secured by a mortgage that does not contain a power of sale clause. To foreclose, the lien holder will have to, so remember, there are mortgages and their deed of trust. The deed of trust has a power of sale clause, acceleration clause, or what is called a due on sale clause. But mortgages do not. So then they must file, oops, I almost said the word. They must file a foreclosure suit. Okay, so this is in a mortgage state. No, it's not a deficiency. A deficiency is something different. In this case, the mortgage, so remember, there are states that use mortgage and there are states that use a deed of trust. A deed of trust explains everything and has many clauses in it of what the lender can and cannot do and what the borrower can and cannot do. In a mortgage state, okay, then they have to go to file a foreclosure suit, go to the judge and file to foreclose. Therefore, they don't have the power of sale that is on the deed of trust, which they can then automatically follow the instructions and proceed with the foreclosure process. In this case, the lien holder has to file a foreclosure suit. So it is in a mortgage state versus a deed of trust state. All right, number 16. Did y'all get that? A deficiency is when a property is sold and not enough money was acquired in the sale to pay off the loan. Therefore, there is a balance still due that is considered a deficiency. And the lender can file a deficiency lawsuit to get the remaining of their money paid. All right, number 16. A homeowner defaults on their mortgage loan. In the subsequent foreclosure action, the lender takes title to the lien property directly instead of initiating a court-ordered public sale. This is an example of what? A, strict foreclosure. B, judicial foreclosure. C, non-judicial foreclosure. Or D, deed in lieu of foreclosure. So homeowner defaults on the mortgage loan. In the subsequent mortgage foreclosure action, the lender takes title to the lien property directly instead of initiating a court-ordered public sale. And I'll have to read the answer on this, because if they don't have to go to court and get a public sale, you know, it could also be C. However, it says homeowner defaults on their mortgage. The subsequent foreclosure action, the lender takes title to the lien property directly instead of initiating a court-ordered public sale. Then this would be considered a strict foreclosure. Okay, and let me read the answer here. So a strict foreclosure is a court proceeding that gives the lender title directly by court order instead of giving cash proceeds from a public sale. On default, the lender gives the borrower official notice. After a prescribed period, the lender files suit in court, whereupon the court establishes the period within which the defaulting party must repay the amounts owed. If the defaulter does not pay the funds, the court orders transfer of title, legal title to the lender. Okay, so it's almost like a judicial foreclosure, but it says that the judge doesn't have to be a court-ordered public sale. So the lender takes title to the lien property directly. So again, the answer is a strict foreclosure. It is a court proceeding. So a public sale, okay, is when they're going to do a normal foreclosure, okay, at the steps of the courthouse. And so they end up allowing other people to buy the property. So instead of going through a public sale at the courthouse steps at the first week or the first Tuesday of every month, might be different in other states, then they have a stricter foreclosure, okay, where the court orders, instead of giving cash proceeds from a public sale, okay, a public sale is when a sheriff or someone that does foreclosure auctions, okay, at the court steps, then they don't do that, okay. Instead of giving, they don't have a public sale, okay. On default, the lender gives the borrower official notice, almost like in a non-judicial state that has a deed of trust. After a prescribed period, the lender files suit in court, whereupon the court establishes a period within which the defaulting party must repay the amount. So it's like a judicial foreclosure, but that would be sold at the public steps, okay? It would be a public sale. In this condition, the lender automatically takes title back from the borrower. It doesn't have to be sold at the court steps. So the lender actually keeps the property, the asset, instead of cash. So typically the lenders want their cash, they want their money, but sometimes certain properties maybe are more valuable to them, or they can get more money doing it differently. So then it would be considered a strict sale versus a strict foreclosure versus a judicial foreclosure. Now let me explain deed in lieu of foreclosure. That is totally different. Okay, so a deed, let's see, Lisbeth answered D, so did Dawn. So a deed in lieu of foreclosure means that the lender has informed the borrower that they could foreclose on them. They're going to start the foreclosure. And in this case, they have one primary loan. And they can ask the lender to take the title back, take the property back without having a foreclosure proceeding. So then if the lender accepts, they have one loan, okay? And that's the only condition that a lender would take it, because if there's any junior loan, then those have to be wiped out in a foreclosure sale at the court steps, okay? At a public auction, at a public sale. So with the deed in lieu, the borrower signs the deed back to the lender and prevents having a foreclosure. The lender gets the property, the asset, instead of cash from a sale. That is deed in lieu of foreclosure. Okay. All right, number 17. All right, number 17. Okay, so you got it. Very good, Lisbeth. So it's a deed given back to the lender in lieu of foreclosure, instead of foreclosure, okay? So borrower is doing it voluntarily and lender has to accept it. Lender doesn't accept it, then they foreclose. All right, number 17. A property owner gives Deanna permission to cross their property as a shortcut to her kindergarten school bus. One day, the property owner dies. What right was Deanne granted originally, and will it survive the owner's death? Okay, so there's like a type of easement, right? So is this a personal easement in gross, which continues after the owner's death, or B, an easement by prescription, which continues after the owner's death? C, a license which continues after the owner's death, or D, a license which terminates upon the owner's death? Sorry, I mentioned the word easement, and so you all selected A. And so what happens here is that the owner is giving them a license, okay, to use their property. So the answer is D, a license which terminates upon the owner's death. Okay, because A says a personal easement in gross. An easement in gross will terminate at the death of the owner, or if the borrower, okay, or if the person using the easement doesn't need it anymore, that's an easement in gross. So they get to use it as long as the owner is alive and on the property, and as long as the borrower needs to use, as the person needs to use it while the owner is still there alive. So once the owner terminated, once the owner died, it terminated. Okay, so it could have been easement in gross if it had says does not continue after the owner's death, but here it said it continues after the owner's death. Prescription, it's a squatter, right? So that doesn't happen. And a license which continues, no, it doesn't continue after his death. It terminates because now there's going to be a new owner, and that new owner may not want him in there. Or it could be the family, and they're like, hey, you had a relationship, friendship with my dad. He was really nice. He gave you that right. So he gave you a license to cross his property. So it's over. He's no longer here. Okay. Number 18. On two adjacent properties, okay, there is an easement. Okay, remember adjacent versus adjoining. Okay. On two adjacent properties, there is an easement that allows property A to use the driveway that belongs to property B. Here, property A is said to be which of the following in relation to property B? A, subservient estate. B, servient tenement. C, senior tenement. Or D, dominant tenement. So let's see. So property A. So the easement allows property A to use property B's driveway. Okay. So remember, we have two different types of parties. So it says here, property A is said to be which of the following? No, it is not A, not subservient. Very good, Lisbeth. They are the dominant party. Okay, the person using the easement becomes the dominant party. They have the upper hand because the owner cannot prevent them from using it. So the owner is the servient tenement. So party A is the dominant. Party B, who is the owner, is the dominant. The servient. Sorry, not subservient, but servient. Remember, dominant and servient tenements. Dominant and servient party. I used to say subservient, and it's servient party. All right. Did y'all get that? Oh, I see. You read the question wrong. That happens. All right. And I do it too. Number 19. A property owner who is selling her land wants to control how it is used in the future. She might accomplish her aim by means of what? A, an injunction, B, a deed restriction, C, an easement, or D, a land trust. So a property owner who is selling her land wants to control how it is used in the future. So we went over a question, something like this earlier, about additional restrictions. Nope, not a land trust, Winston. The answer is a deed restriction. Okay, that owner wants the property only used a certain way. Okay, maybe is okay, they're selling their land. Okay, and maybe their other property is next to it. Okay, therefore they want to control what type of homes are going to be built in this land. So that would be a deed restriction. Okay, a land trust, it is a it's how do you end up owning the property? You put it in a trust, so you have three parties, right? The trustor, trustee, and the beneficiary, and that's used for asset protection. Okay, so here it says a property owner is selling their land and they want to control. You don't control it by a land trust. You protect it and you create multiple levels of asset protection by having a land trust. Okay, it doesn't restrict how it could be used in the future. That would be a deed restriction. So very good. 219B. All right. So good, y'all are still hanging on here. Probably the individuals that do national are so used to me doing national at the beginning that they didn't show up or didn't know when to show up. All right, so that was 19B, deed restriction. Number 20, what distinguishes a lien from other types of encumbrances? What distinguishes a lien from other types of encumbrances, right? Clouds on title. A, it involves a monetary claim against the value of property. B, it lowers the value of a property. C, it is created voluntarily by the property owner. Or D, it attaches to the property rather than to the owner of the property. What's the difference between a lien from other types of encumbrances? Remember, you can have an encroachment, a cloud. Those are encumbrances, right? So what is a lien compared to the others? Yes, very good. It is A. It involves a monetary claim against the value of a property. That is a lien. It's a financial lien. The others become clouds on title. They're attached to the property and they have to be cleared, right, in order to be able to sell a property in a fee simple freehold estate condition, or ownership, I should say. Very good. Trying to remember something else. Oh, I forgot to unlock the door. Hold on. Sorry, I forgot to leave it unlocked.
I didn't know whether you were doing your show or not.
Yes, I am. I'm doing my class. Sorry, y'all.
Come on, baby.
See you later, Bailey.
Bye.
Bye. Okay, number 21. Which of the following defines actual notice? Actual notice, okay, versus constructive notice. A, it is notice published in a newspaper. B, it is knowledge one could have or should have obtained. C, it is notice explicitly stated in a legal document. Or D, it is knowledge received or imparted through direct experience. Oh my goodness, excuse me, through direct experience. Type your answer in the chatty chat. No, it is not C, you all. The answer is actually D. It is knowledge received or imparted through direct experience. So you're actually giving someone notice. So the person is actually receiving notice from someone, or from, it could be a piece of paper. Okay. Constructive notice, it's recorded and they may or may not know. So actual notice, they're actually hearing it or reading it from someone. I notified you either by text or email or phone call or in person. That is an actual notice. Number 22. Okay, y'all got that? Actual notice is when the person is notified. Okay, constructive notice is when it is publicized, recorded and publicized, and they may or may not know about it. They weren't informed personally. Okay. Constructive, it's recorded and it's known by everyone, public. Which of the following defines constructive notice? Oh, okay. It is a notice published in a newspaper. It is knowledge one could have or should have obtained. C, it is notice explicitly stated in a legal document. Or D, it is knowledge received or imparted through direct experience. It sounds like it's B, but you got to read the answers again. I'm sorry, it sounds like it's A because I said it would be published in the newspaper, but there's a better answer, okay? Because notice published in the newspaper is not totally correct answer. So the answer here is B, okay? And I'll read it. So it is knowledge one could have or should have obtained. Okay. It doesn't mean they do have it. So it could have been delivered, mailed, and they never received it. It could have been published in the newspaper. It was recorded. However, they could have or should have attained, but doesn't mean they did. Okay, so constructive notice or legal notice is knowledge of a fact that a person could have or should have obtained. The foremost method of imparting constructive notice is by recordation of ownership documents in public records. So one, they are recorded. Specifically, title records. Since public records are open to everyone, the law generally presumes that when evidence of ownership is recorded, the public at large has received constructive notice of ownership. Therefore, the individual could have or should have obtained that notice. That doesn't mean that they did. So just being published in the newspaper doesn't make it a constructive notice. It has to be recorded. And even though it didn't say on here it's recorded, it is knowledge that one could have or should have obtained by seeing it in the newspaper, or by receiving the document, or having a sheriff deliver, okay, the filing of the documents. So the answer is 222B. They have knowledge. So they were almost, close together. And so on actual notice is the knowledge is received, okay, or imparted through direct experience. Here, the knowledge, it is knowledge one could have had or should have obtained because it's public to everyone. That doesn't mean they did. Okay, number 23. Ownership of real estate can be transferred voluntarily or involuntarily. The three ways title can be transferred voluntarily are by how? A, grant, deed, and will. B, escheat, deed, and covenant. C, title, certificate, will, and deed. Or D, sale contract, deed, and warranty of Sison. So the three ways that property can be transferred voluntarily. So how can somebody convey, gift, or will to somebody else? Yes, A. The answer is A. It is done voluntarily by a grant, deed, and will. Okay. When it is escheat, right, that's when a person died and it went to the court because there were no heirs. So that wasn't voluntarily done because the person was already deceased, right? And title, certificate, will, and deed, well, owner has to grant it first. A title certificate is not state that it's transferred voluntarily. A sale contract, yes, it is. It could be voluntarily or it could be a forced sale contract. Okay. A deed, yes, it's okay. A warrant of Sison, you know, a seized warrant. So that one wouldn't apply. All right, number 24. Moving right along. What is the function of recording a deed? A, it makes it the deed valid. It makes the deed valid. B, it causes title to pass. C, it gives constructive notice of ownership. Or D, it removes all prior recorded encumbrance. We just discussed it. Tap your answer in the chatty chat. Come on, come on. No one? Constructive versus actual. Yes, the answer is C. It gives constructive notice of ownership, right? When a deed is recorded, now the public knows about it. Everybody knows about it. What makes a deed valid is when the grantor signs the deed and it is delivered. Then that's when the property is conveyed. However, it is then recorded, and that makes it a constructive notice of ownership to where everyone knows. Okay. Number 25. The only clause that is actually required in a deed is the A, habendum clause, B, granting clause, C, reserving clause, or D, tenendum clause. I'll get to your question in a moment, Winston. Yes, very good, Lisbeth. It gives a granting clause. The only clause that is actually required in a deed is the granting clause. Grantor grants, you know, and conveys property to so-and-so, and they sign it. So the granting clause or premises clause is the only required clause. It contains the conveyance intentions. names the parties, describes the property, the legal description, okay, and indicates a nominal consideration. What was the amount that it sold for? Okay, so the answer is 25D. I'm sorry, 25B as in boy, not D as in dog. Very good. All right, so Winston asked the questions. When a deed is recorded, it gives notice. It gives constructive notice. Be specific. It is constructive notice, not just notice, okay? Because it could be actual notice, which is when a borrower actually receives the deed, okay? And it's because the grantor, okay, the seller, the owner signs the deed, but when is it actually in effect? When it is delivered, signed, sealed, delivered, right? And so the borrower gets actual notice. Okay, they are informed. You are the owner. Here is the deed. Now it gets recorded. So they get a copy of a deed at the closing that the seller signed. However, it's not recorded yet. The title companies will then send it with a courier to the circuit court in order for it to be recorded. And there's a third party involved that does the witnessing and recording, right? So recording gives constructive notice. All right, y'all. So that's the end of tonight's session. So we did the state portion first and the national at the end. For those of you who took the exam and did not pass, okay, remember not to be so hard on yourself. And it didn't mean that you weren't supposed to become a realtor. And Lisbeth is a great example that she has still been sticking with it. Okay, she's got glue, okay, stuck to getting that real estate license. Right. So I'm so proud of you, Lisbeth, to having not passed today and attending, not getting all bummed out and feel sorry for yourself or be really hard for yourself. I know it's hard not to pass. Been there, done that. Okay. and I didn't pass, but with one question. All right. On the national or on the state when I took it in Oregon and in Michigan. So it was sad. Okay. But that was then. I have a different attitude now. So the attitude to have is that, okay, so we didn't make it this time. We've got to study more and prepare more in order to obtain what we want, our vision, our dream, our goal. And that is to become a realtor. All right. It might take some a little bit longer. Doesn't matter how long it takes or how many times. Right? Thomas Edison took him about 1,000 times, okay, before he created the light bulb. He didn't fail. He just said, oh, okay, well, that way didn't work. I was missing something. Had to do it again until he invented the light bulb. So you are going to pass. You're very welcome, Lisbeth. I'll pass with some more study. Yes, you will. Then study that vocabulary, okay? And I noticed that most students watch the vocabulary videos very little. And it's more the questions. However, the questions help you realize that, oh, okay, I got to study more vocabulary. And you can go and study your own vocabulary list or the flashcards, or you can go to Quizlet, okay, and study flashcards there. You don't necessarily have to purchase them. All right, y'all, if no questions, remember that if you have not gone to my YouTube channel, go to the YouTube channel, tap that subscribe button, click that little bell so you're the first to get notified, and thumbs up to this video if you enjoyed it and it is valuable to you. There are a few of you on here, so remember to tap that subscribe, that thumbs up. Thank you for those who have done it, okay? And also, I am a realtor practicing real estate, so I'm finalizing a deal right after class. Okay, you all, until next time, I love you. Keep studying, focus, and remember and affirm, I passed, I passed, I passed, and you will pass. Ask, believe, and receive. Got you all later. Until next time, bye.